I mean, it's someone has not returned serve, no report.
Yes, Mr. President.
Who's appearing for the case?
I'm looking for a case.
Charge is for being shot with a bullet, no arms act.
Yes, I'm second as per charge sheet.
We are not concerned with the charge sheet.
But no,
We are concerned with the charge.
Yeah.
Charge frame under which section?
307.
That's what I'm asking. No charge frame for the arms act.
Mm.
And charge sheet was filed under the arms act.
I'm second 307.
Why was the arms act dropped?
No.
Then arrange the files. Both appears to be here. Arrange the files. Then you go down. Please leave it here. Then pick it up. Yes. Accused present along with defense counsel, Sri so-and-so, prosecutor so-and-so present. Summon issued to the witness not returned. It has become a regular practice for the summons to remain unanswered by the executing authority. A committee has been constituted at the district level, headed by a deputy committee, headed by a DSP, to ensure that the summons are served effectively. It appears that the committee is only on papers. Copy of this order shall be communicated to the SP, where Jaintia. This court, the summons will not be issued only for the purpose of being issued. If there is no effective execution, persons responsible for executing the summons shall be answerable.
Signing, Mr. Chair.
Today's examination of the FSL. She informed me yesterday that she will not be able to appear today due to the wedding ceremony in her family.
And then what are we doing here? Peeling some banana here in the court. People will not attend the court as they have wedding ceremonies. They have parties, last night hangover. These are not the grounds to adjourn the matters. Please give some good grounds for adjourning the matters. Otherwise, we can secure the presence forcefully. We don't want to embarrass them. Not such kind of grounds for adjourning the matter. Someone issued, where is the accused?
Accused here, present.
Accused present along with defense counsel. Prosecution series also present. Someone issued to the witness return. Learned prosecutor submits that the witness could not appear today as he has to attend wedding. What is the charge he is standing?
302, Your Honor.
Huh?
302.
In a trial for an offence under section 302, witness is praying for deferring the trial on the ground that he has to attend wedding. Such kind of prayer is a mockery of a trial, of a session trial. Prosecutor shall bear in mind before such prayer is made for adjourning the matters. If the witness fails to appear, the prosecution is at liberty to take coercive steps to secure the presence of the witness. Refix. Yes.
Everyone of you from the week, from Zoom.
Yes. 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 What is it? Yes, who is for the prosecution?
Yes, I'm
Yes. Matters is what?
Evidence, Your Honor.
evidence, you know.
How many witnesses has been examined?
7. 7 witnesses have been.
How many more to be examined? What
There are
is the
some more,
application?
you know.
What is the application filed by the prosecution? Dated 28th October 2025. What is this application? Have you served the copies to the accused?
Or not it, you know.
Yes. Served the
I'll-
copy.
I'll give them.
What is this application?
This witness, nodal officer of Vodafone has retired. So this new nodal officer informed me that he has retired, they have no contact of him. So all this electronic evidence, submitted by him electronic evidence. So he may be allowed to depose to give evidence on his behalf.
What electronic evidence? What are those electronic evidence?
It's called CDR, called the detailed report, submitted to the police.
Where is that? Is it part of the charge sheet?
Yes, sir.
Through this application, what do you want? What is section 336 BNSS? It will be always advisable that when you file any application, when you are referring to BNSS, also make a reference to the CRPC also.
Yes.
It will be easy for us to know which sections we are making reference to. Yes, yes. What is the 366 or 336? What is that?
336. Evidence of public servant, experts, police officer in certain cases.
Yes. You have any objection? But what is the document? This witness is for what purpose?
It's a full detailed report of accused. One of the accused person.
What? This witness,
All
what is his
records, yes,
application?
all records of the mobile phone, mobile tower, some,
Call records.
yes.
What is he going to do? That call record was
The-
extracted by him.
Extracted by his previous, that nodal officer.
All right.
Okay, the nodal officer submitted a certificate under section so and to
What is that notification, Robert?
I have enclosed the notification issued by the
Yes,
government of Meghalaya
Yes, yes.
Police
Please read.
Department in respect of this matter.
So this man is a public servant. Vodafone is what? Government.
No private, you know.
And then
They will be expert because they were electronic media, electronic means.
all right. Deposit of success
Paragraph 3, procedural guidelines and use of electronic means.
just read this. Read para 3.
Procedural guidelines and use of electronic means. The deposition of successor officers or experts may be permitted through electronic means wherever legally admissible in order to facilitate timely proceedings and reduce procedural delays. All deposition must comply with.
Huh? So where are you reading and what do you want to impress on the court? Paragraph 3, procedure guidelines and use of electronic means.
Yes.
You are reading para 3. Para 3 of the government notification dated 25th July 2025.
Yes, this one.
Yes, yes.
Now, in respect of this application, this witness falls under expert.
All right, he may fall an expert, but what do you want to impress on the court? What do you want to say through this notification dated 25th July 2025?
In the absence, in the retirement or death of the,
Please read para 3.
this notification shall apply to
Para
all.
3.
Yes.
Procedure guidelines and use of electronic means.
Yes. The deposition of successor officers
Hmm.
or experts may be permitted through electronic means wherever legally admissible in order to facilitate
Now,
timely.
legally admissible.
Yes.
Now, this call records is legally admissible. When does it become legally admissible? Call records becomes legally admissible when? When does the call record becomes legally admissible?
A certificate, the 65B
Where is the certificate?
was issued in this behalf
By whom?
by the nodal officer who issued the call detail.
No. Commissioner Secretary will not become High Court. He issued this notification. This should be in the rules of the criminal rules of the High Court. He has issued the notification and regulate the court. How should the court proceed with the trial? The Commissioner Secretary will decide. Read section 65B. What is the corresponding section of 65B under the new Act? You mean to say that somebody else can come and establish the 65B application? What is the pro forma prescribed for the certificate on 65B under the new Act? No. Deposition of a successor officer or an expert may be permitted through electronic means wherever legally admissible in order to facilitate timely proceedings and reduce procedural delay. All deposition must comply with the established protocol to maintain legal sanctity and procedural integrity. They are just using those words to see that, create more confusion. When the law is very clear, is that how do we admit electronic evidence? Electronic evidence cannot be admitted without a 65B. Now you want that 65B itself should be proved by somebody else. What does 65B says? What is the corresponding section of 65B? What is the corresponding section of 65B? 63. Let's see.
63.
Yes.
Admissibility of electronic records. Notwithstanding anything contained in this adenium, any information contained in an
Anyway, you are objecting to this application?
We haven't received a copy of that.
Please have the copy.
Yes, I'll give it.
We will not ask for the show cause also. If the petition is not maintainable on the face of the record, why should we waste time in asking the other side to file show cause? Let us see that whether legally is maintainable or law it's maintainable. 65, section 63.
63.
Read, please read.
Admissibility of electronic records. Number
And
one.
then read, see, that's why I'm emphasizing on the word, para 3. The deposition of a successor, officer, or expert may be permitted through electronic means, wherever legally admissible, in order to facilitate timely proceeding and reduce procedural delays. Now, when the document itself is not admissible, he'll come in the court for what? This call details is admissible without the certificate under section 65. That call detail is what? Nothing, a photocopy, computer generated. It becomes admissible only when you comply with the certificate. Let's look at the pro forma of the certificate. The pro forma has been prescribed, isn't it? How do you make the certificate? And in the certificate, there has to be a hash value. To see that it was not tampered, the hash value from the original document, from where it was extracted, and the copy here, we can check it. And somebody has to satisfy that this is the original copy. This is extracted and not tampered. See what? Notwithstanding anything contained in adenium, which is printed. Please read 63. Section 63.
Notwithstanding anything contained in this adenium, any information contained in an electronic record which is printed on paper, stored, recorded, or copied in optical or magnetic media or semiconductor memory, which is produced by a computer or any communication device, or otherwise stored, recorded, or copied in any electronic form, hereafter referred to as the computer output, shall be deemed to be also a document, if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings without further proof or production of the original as evidence, or any contents of the original, or of any facts stated therein of which direct evidence would be admissible.
Yes, condition. What is the condition?
Number one, the condition referred to in subsection 1 in respect of a computer output shall be the following, namely, number A, the computer output containing the information was produced by the computer or communication device during the period over which the computer or communication device was used regularly to create, store, or process information for the purpose of any activity regularly carried on over that period by the person having lawful control over the use of the computer or communication device. Number B. During the said period, information of the kind contained in the electronic record, or of the kind from which the information so contained is derived, was regularly fed into the computer or communication device in the ordinary course of the set activities. But C, throughout the material part was operating properly, or if not, then irrespective of any period in which it was not operating properly or was out of operation during that part of the period was not such as to affect the electronic record or the accuracy of its contents. And number D, the information contained in the electronic record reproduced or is derived from such information fed into the computer or communication device in the ordinary course of the set activities.
Yes. 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 So you mean to say the certificate can be proved by any other person other than the person who was in control of the electronic device?
No, yeah.
What is the charge?
302 yuan.
What is the significance of the call records? How is it relevant in the trial? How is the call record relevant in the trial for the prosecution? You just serve the copy. You like to respond to it. Is there nothing about on facts? Nothing.
We'll have a hearing on the next.
Huh?
Receive
Serve the
copy.
copy to them.
Bringing it on.
Huh?
Preparing it.
All right. Serve the copy. All right. How many more witnesses to be examined here?
I don't know.
How many more witnesses?
There are 15 witnesses as per the charge sheet, Your Honor. 7 has been examined.
But we have summoned 2 witnesses. What happened to Dr. N.M. Kakali?
No report received. He conducted the post-mortem.
Okay.
Yeah, sir.
The prosecution has filed an application under section 336 BNSS 2023. Jaintia, praying for summoning a witness Shri Bhargav Sharma, Nodal Officer, Vodafone Idea Limited. Full stop. The prosecution is praying for summoning the above witness in as much as the witness the witness would establish the generation of we would establish the computer generated call records Defense counsel present here, present before court. Apparently submits. Call record is part of the charge sheet. Call record has been supplied to you people.
Yes.
Call records are part of the charge sheet. Pusto. The prosecution is relying on a notification dated 25th July 2025, issued by the Government of Meghalaya, Home bracket Police Department. This notification was issued in exercise of power under section 336 of BNSS. In other words, the government by a notification mentioned above intends to regulate the manner in which the power under section 336 is to be exercised by the court. This court would not like to delve into the question whether the rules under the BNSS is to be regulated. Rules under is in a rules is to be framed by whom? Be that as it may be, the notification is in force. Are you filing reply to this application?
We'll have hearing on. We'll have hearing time.
No, will you file a reply or not?
We haven't received an extra also.
Apply the next year.
Okay, we'll fix or reply.
You file reply?
Okay. Reply and hearing.
Defense counsel prays for time to respond to the application filed by the prosecution. Pray aloud. This matter will come up on Tuesday. Next Tuesday. For show cause and hearing. Any reply filed by the accused persons shall be supplied to the prosecution beforehand, so that the matter can be heard on the next date fixed for hearing of the application mentioned above. Full stop. Pendency of this application would not delay the trial. The previous orders manifest that notice was issued to doctor. Give the name of the doctor, some Kakoti or Kakoli, somebody.
Kakati.
There is no response to the notice. There is no response to the summons issued to the doctor. The prosecution shall take assistance of the investigating officer and ensure that the witness is present on the next date fixed. Who are the accused persons are present? All?
Other two, the IUTP on.
Who are
Thomas
the
John
UTP?
Clem.
Who are UTP?
Banisola and Thomas John.
Thomas John Clem.
Why they are UTP?
This Banisola is not UTP in this case.
Huh?
He got-
No, if there are 4 accused persons, 2 are on bail and 2 are in custody. It's not fair.
Thomas
Unless
John,
they have violated
yes.
the bail
Thomas John
conditions.
Muslim has been detained in another case.
Another case.
Not in this case. So they are not UTP.
No.
So don't tell them that they are UTP. They accuse Bani Sana and Thomas John Reclam produced before this court on the strength of production warrant. They accuse Emiwat Nomtudu and Ham Johi Dakhar present. The accused persons shall be produced before this court on the next date fixed on the strength of production warrant. No remand. Yes, next please.
Come on, Imam.
Yes. 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 Mm. Yes. What is this?
Accused is under representation.
Why?
He is having some personal difficulties.
What is that person? He's on bail, isn't it?
Yes, Your Honor.
So, by granting bail, we have to impose some conditions. No? Was there such conditions that due to his personal difficulties will examine his appearance? What is that personal difficulty? You are abusing your liberty. Your liberty becomes a personal matter for you now when you are standing trial. You are not free. You are on bail. And one of the bail conditions is that you'll appear before the court and stand for trial. What is that personal difficulty?
You inform me like that.
No. It's not a question of exempting you. Now, if we are kind to you, we have to be kind to everybody. Why should we ask others to come? Everybody has got some personal work to do. Why should you come to the court? Unless we come to know that what is that personal difficulty is different from something which is very genuine. Otherwise, why should everybody come to the court? Only the lawyers will be there in the court. Why other accused? Why will they come? Why? Why will they come? When you have personal difficulty, we exempt you. Others, we say no, they have to come. Especially those villagers, they come. From Mukro and all those places, they come. Even they have to hire a taxi, 1,000 rupees they pay and they come. Only for the matter to be adjourned. He'll appear. No personal difficulty. Yes. What happened to the witness?
The summon issued to witness received by the brother, but the witness didn't turn up till now.
What is the charge?
326 and 302.
When was the last witness examined? Okay. September we have to examine the witness. Okay.
8, 9.
It is. The accused represented by defense counsel Shri M.K. Puthu has filed a petition number 16/25 dated 28/10/2025 in trial praying for dispensing the personal appearance of the accused for the day. The ground on which the accused is seeking dispensation of his personal appearance is personal difficulties. You write in bracket emphasis. The court, this court has to be consistent while passing order. If an accused person is allowed to if the appearance of the accused is dispensed with on some personal difficulty without the personal difficulty being spelled out, then all the accused persons should be allowed to be represented by defense counsel. This court is not inclined to entertain. This court is not inclined to entertain such sketchy ground for dispensing the personal appearance of the accused. If the accused fails to appear during the course of the day, coercive steps shall be taken to secure the presence of the accused. And what happened to the witness?
Someone received by the brother.
This is what cultivation season now.
Yes.
From which place?
Mukro.
Mukro. Okay, we can consider. Okay. Someone issued to the witness return duly served. This court has passed series of orders educating the executing officers that the summons should be served to the summonee and not to the relatives. It appears that the orders passed by it appears that the order passed by this court does not make any difference. Which police station is this?
Batu.
Huh?
Batu office.
All right. The officer in charge of the Barato police station shall respond to this order as to why the summon was not served to the summonee. Prosecution is at liberty to take fresh step, refix for evidence. If the accused fails to appear during the course of the day, without any further order, non-bailable warrant shall be issued against the accused and notice to the bailers.
Groups, the class, group.
Yes.
The witness, yeah,
Hmm?
the witness. In this case, we have examined two witnesses, one eyewitness and one complainant.
What is the charge?
There's a total,
Accused no Dakhar present along with defense counsel, Sri Arvindo. Record reveals that the prosecution has not taken steps to summon the witnesses. Prosecution shall positively take steps to summon the witnesses. If no steps is taken, without any further order, PW shall stand closed.
Whereas, yeah.
Yes. Hmm. Yes. Yes. Giral Suchia, what is this matter?
This is fixed for final argument.
How many witnesses? What is the charge?
The charge is under section 326 and 307. 7 witness.
We'll hear it. We'll pass the judgment. No judgment.
Pula.
Yes, what is this? Yes,
It's for CC.
yes. Yes, you want to argue before consideration of charges?
Yes.
Yes, who's appearing for prosecution?
so I'll have to receive the CDNA.
No, we'll hear it before judgment. You tell why we should discharge. If you can convince us, discharge. The last order says that they fix this matter for hearing before consideration of charge. We were notified that on the last day, it was fixed on 15/9/2025. Now we are on 28/10/2025. More than a month. Notified that matter will come up for hearing. Yes, please tell me. Yes.
Your Honor, I would like to rely on the statement of the mother of the accused person. On her statement,
So first tell me what is the charge?
the charge is 302.
All right.
And the
In
prosecution
302, you are praying for discharge or you are praying for alteration of charge?
alteration.
You want the charges to be altered under which section?
Your Honor would like to self-defense, Your Honor.
Hmm?
Or private defense as recognized under section 97.
You read Evidence Act, section 105. Will be governed by the BNSS, this Bharatiya Nyay Sanhiti. No, what is that Evidence Act? Where is Evidence Act? Sakshya Adhinam. Please read section 105. The answer will be there of the Evidence Act. Yes, please read.
The burden of proving that case of accused come within exception.
Hmm.
When a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any of the general exception in the Indian Penal Code or within any special exception or proviso contained in any other part of the same code or in any law defining the offense is upon him, and the court shall presume the absence of such circumstances.
All right. So, You are claiming self-defense. Isn't it? Self-defense will come under chapter IPC from section 97 to
106.
106. These comes under the exceptions. So this exception, the burden of proof is on you. Otherwise, the law will presume that there is no self-defense. The last part of section 105 says that the law will presume that there is no self-defense. So at the stage of framing charge, can you argue on the self-defense? Show me the evidence from where you can say that it was an act of a self-defense.
Further on the statement of the mother of the accused person.
She's an eyewitness.
Yes, she's the eyewitness.
Yes.
She stated that then my husband took the doll. On examination, she to state that my name and address is as stated. I have 2 sons from my first husband, and I have separated with him. Shri Hamkom Shala is my eldest son, that is the accused person. I have married with my second husband, that is late Olino Rumbai, for around 2.5 years, and he used to beat me many times. And previously, when he beaten me, I used to go to my mother and my sister house, for I scared that he might kill me, and he threatened me if I inform to my relative that he will kill me. I didn't dare to reply back to him. Also, in order to control his anger, my scare still remained on my right palm. My scar still remained on my right palm. Also, for he burned me with the cinder of the fuel wood. On the 16th of March 2023, my son Sri Hamkom Chula came from work from Molai, and in the evening time at around 6 to 7 p.m., my son asked me if I have ready for the dinner, and I said that it has not yet ready. Then he said he will go to his auntie first and left home. Then he returned home at around 9 p.m. from my sister's house. When he came, he had food and then he slept. My husband, that is the deceased, he argued with me and used abusive language by saying that your son, in Penang language, in Penang terminology, and I told my husband, let me ask him in the morning, for he just came home, and I will ask him how much he got money. Then he said, why do you hide? For he already gave you money. Then he slapped me and pulled me from my hair, and he beaten me with a rod from my chest. Then he said he will kill me, and I told him that I will go to my mother's house. My son heard that and said to my husband, you always beat my mother, and she always cried because of you. I heard that my relative told me that I am away when I am away from the home, also that you beat my mother a lot. So here the mother of the accused stated, then my husband took the dao to kill my son, and he defended himself, and he did not hit by the dao. At that time, I went outside, and they fight each other. I never expect such incident will took place. As it was dark, as there was no current on that night, I didn't notice that my son has killed my husband also. I just called my son to leave my husband and to go to my mother's house. Then he came outside. As we were scared for my husband that he might follow us from behind, as we used to hide ourselves to my mother's house, then we left to my mother's house. If my son does not defend himself, I think he will die from the dao, or I will die for my husband was so furious on that night, and he took whatever tool he found near him.
Postmortem report. Postmortem report.
The cause of death was due to shock and hemorrhage.
Injury.
Cut wound in right side of his chest, 1 centimeter into 1/2.
All right. Okay. What is the cut wound? What? Cut. Where the injury? Where is the injury?
On his right side of his chest.
Right side of his chest.
Yes.
Injury caused by?
Caused by shock and hemorrhage.
Yes. Yes. Then what is this? This is your witness. This is the witness. Your eyewitness.
We also have to look at other witnesses also, not only one.
That's enough. The eyewitness there.
He's, maybe she's an interested witness, she's a family member.
No, she may be
Naturally,
interested.
she'll protect Her son, naturally she will protect her son. She has to choose one. One has died, one is alive. She's the mother.
No, she's the only interest witness that present with the accused
No, she's also
in
saying interest.
as a witness.
But I think if this, then what are the other evidence against the accused?
You have to check.
What are the other evidence, prosecution evidence? Her learned prosecutor, so her learned.
Only the mother, Your Honor, present.
Her learned prosecutor, so her learned defense counsel, Srimati so. This matter has come up for hearing before consideration of charges. Charge sheet against the accused has been filed under section 302 IPC. The prosecution is relying on the statement of 7 witnesses to establish the charge. Mother's name is?
Jaintia Shila.
There is one eyewitness in the instant case. Full stop. The eyewitness is the mother of the accused. The learned defense counsel has drawn the attention of this court to the statement of the mother bracket eyewitness recorded under section 161 of CRPC during investigation. And submit them. On plain reading of the statement of the eyewitness, it establishes that the act of the accused was in self-defense. Stop.
Just to adopt in the postmortem. Says the cause of death was due to shock and hemorrhage as a result of cut wound on his neck and right chest. There are two multiple wounds, here, not a single wound.
There is a cut. And what have the investigating officer sees? An axe. You can't have a cut wound with axe. And that too in the neck. Look at the axe is there. C27. If somebody uses axe on the neck of somebody with this axe, he'll be beheaded. Look at the axe which is there. It doesn't matter how many wounds are there. The law is settled on self-defense. You don't start counting in what will be a reactions. This cannot be a measured reactions.
As a result of examination, also the blood stain on the axe is human blood.
Yes, she's admitting I hit. Not saying that I did not hit. But the act was in self-defense. It is not her witness. It is your witness. Your eyewitness saying that this is what exactly happened. Now you cannot turn around and say that no, my eyewitness is not speaking. We are not on trial. Now even if you bring the witness, you will not make out a new case in the court.
Yes.
At the most, you'll be proving that her statement under 161. And if you want to bring something more than what she has stated under 161, that will squarely fall and in a case of improvement. What you have not stated under 161, you come and tell before the court. It amounts to having a new, altogether a new case before the court. What is that?
The plain reading of the statement of the eyewitness establishes that the act of the accused was in self-defense.
In self-defense. This court has also brought to the notice of the Defense Counsel Section 105 of the Evidence Act, which casts burden on the accused to establish the act of the accused is an exception, which is not an offense, which is it is an exception and does not constitute offense. Failing which, the court shall presume there exists no exception at this stage. At the stage of framing charge, the court will not appreciate the evidence or make any roving inquiry to the material in the charge sheet for the purpose of arriving at any conclusion. For the purpose of discharge, the court has to accept the argument that even if the prosecution evidence is unrebutted, no case is made out to frame charge. In other words, Section 227 of CRPC envisages, if there is no grounds to proceed for trial, in the case in hand, the defense is not pressing for this court to appreciate the evidence of the eyewitness. The defense is simply relying on the statement of the eyewitness and submits that if the evidence of the eyewitness bracket mother is accepted to be true, a clear case is made out of self-defense. This court finds force in the submission made by this court finds substance in the submission made by the defense counsel. The defense counsel, do you have any precedent to show that at this stage also a plea of self-defense at the time of framing charge, we can discharge? Do you have any precedents? I've not come across in the 302 case you admit that I have killed somebody and you can discharge. We can discharge. Show me any law that at this stage, if a prima facie, if a case is made out from the prosecution evidence, that because the burden is on you. Now the burden of proof is discharged only during trial. Trial is yet to commence. So, but even while arguing, the burden of proof is in the on the prosecution to establish that there is a prima facie evidence for framing charge, from where assumption can be drawn that charge can be framed. Okay. But in this case, it is for you. It is for you to satisfy the court that with these materials we cannot frame charge. And we can see you're not praying for acquittal, you're praying for discharge. The question of self-defense comes when one, first, if it is established that you are the author of the crime, but the act is not a crime because you did it in self-defense. Self-defense cannot be defined. So you should give me some authority where at the time of framing charge, power under section 227 can be exercised for the purpose of extending the benefit of self-defense. Self-defense is not to be determined only during trial. Self-defense can also be determined at the time of framing charge. If you can bring any decision, we'll discharge you. Come with any law to show that the power to discharge a person under 227 can be done, like for example, section 84. If you are claiming that you are unsound mind, the act was committed because of your unsoundness of your mind. This plea can be raised at the time of framing charges. So, like self-defense, the plea of self-defense can be raised at the time of framing charge. And if you can satisfy from the prosecution evidence that the case is made out of self-defense, you are entitled to discharge. You have any authority, we will discharge you.
So your Honor can fix on next day after.
Tomorrow.
Yes.
Tomorrow.
Yes.
Yes, prosecution also see tomorrow. See tomorrow. But see, you don't have any other evidence. She's not bringing any evidence at
Yes,
this
yes,
stage.
consider.
See, be very clear about it that you are not bringing any evidence at this stage, nor you are permitted to bring any evidence at this stage. Argument before charges shall be confined to the material which is there in the charge sheet. You cannot be allowed to bring your evidence. If you want to bring some evidence, the only plus point is this: is that you are not arguing anything which is not part of the charge sheet. You are arguing from the charge sheet for the purpose of establishing self-defense. So that is good enough. That you are not bringing anything new. So because a prosecution cannot rebut their own charge sheet. They cannot disagree with the charge sheet. It's their document. You saying only that it's their document, let it be the way it is, accept it to be true for the argument's sake. Let us presume that the statement of the witness, eyewitness, is true. Still no case. Or it is a case of self-defense. From their evidence. Place a decision on that at this stage, in excess of power under section 227, we can discharge an accused on the ground of self-defense, if it is argued from the prosecution evidence, or any exception. 84 also we will extend the benefit. It is on the same principle. Because 84 also section 105 is there. That because the 105 says that we have to presume that these things does not exist. Self-defense does not exist. Unsoundness does not exist until unless you prove it. You discharge the burden. Okay, and discharging the burden of proof will not be equally like the prosecution beyond reasonable doubt. It will be on the preponderance of the evidence. Yes, next. We'll take it tomorrow. That will come up tomorrow. Just you see on that part also the prosecution also. Whether at this stage we can do that.
Yes, yes.
Yes, next. Yes. Yes, yes.
Jeremiah Lulu,
Yes.
Shimki,
Yes.
Trayvon,
Yes.
Leaky,
Yes.
6 for
Nishan.
3, no?
Huh?
Sungkon.
6 for 3. Oh my, it's absent, you know, without any step, you know.
This is what Bruto.
No,
It's harvesting season.
Yes.
Your Honor, my apology for the accused Jeremiah. I have given him tomorrow's date.
Okay, we'll do.
I'll make sure they'll come on next day.
Yeah, like, he's presenting the accused, so and so present, Srimati so and so present. This matter is fixed today for examination of the accused under section 313. Defense counsel some praised that praise for time. On the next date fixed, the accused person shall be present for their examination under section 313. Yes, next.
Objection.
Yes.
Release to
Waiting for petitioner.
What is this case?
For appearance.
Huh?
The advocate.
Sorry?
Fix for appearance.
Advocate. You are not advocate. Whose appearance?
Appearance, the petition.
What is the succession amount?
10 lakh.
Huh?
10 lakh left by the deceased.
How are you related to the deceased?
The wife,
What is the evidence that you are the wife?
marriage certificate.
Which page? Marriage? How many children you have?
Only one.
How old is he or she?
The children.
Huh? How many children you have?
Only one.
He or she? How old is he or she? Minor or major?
Minor.
What is the age?
The birth certificate was not there.
Huh?
The birth certificate of the children was.
Not there. And this man was working somewhere?
Yes.
Where?
As there at the veterinary at Nongkro.
How old are you?
Yeah.
The petitioner.
Petitioner is
55.
yes.
You have only one children.
One.
You are the first wife.
Yes. Yes.
You are working somewhere.
No.
And this man who died, he didn't have brother, sister, mother.
Brother.
Where have you stated in the petition?
In the
Units for
in point number 8, you are not that he has left only one brother.
where is the brother? Brother. He's given NOC.
Yes.
Where? He's there, brother.
And
He's come.
No.
Daughter is 21 years. No. A daughter has to come. Where is the daughter? Daughter. You will take all the money, you will not give to the daughter. This is the father's money.
Yes, sir.
Daughter is married?
No.
We will not go by NOC. The daughter will examine the daughter. The daughter has to come. Where is the petitioner?
Petitioner is now she is inform her to but
General notice was issued. Learning council for the applicant present. General notice for a period of 1 month was issued, calling upon the interested person to file objection, if any, with regard to the prayer of the applicant for the grant of succession certificate. With regard to the debt and sureties left behind by a deceased husband named
Abraham Power.
huh?
Abraham Power.
Abraham Power. None has come forward to file any objection. The petitioner had left behind. The deceased had left behind the applicant bracket wife, brother, and a daughter aged about 21 years. The brother, daughter shall appear before court on the next date fixed for the purpose of their examination. Fixed for appearance. You bring them. They'll confirm that they have given no objection. Yes, next.
I done the
Hmm.
Bajaj Allianz General Insurance.
Although I tend to file the with plus under 83. Next, I 6 for time to file with. I'll file next week positively.
If you do it for what?
For the suitability.
Matter proceeded ex parte
Yes, sir.
against all the OPs.
No, only the for OP1 and 2 insurance is
Hmm.
here.
What is this matter? You are appearing for OP insurance.
OP insurance, Your Honor.
You file a written statement.
Yes, Your Honor. Filed written statement, letters of witness. This step by the claimant, Your Honor.
You
File
did not
deposition.
file even a deposition of even a single witnesses.
No, Your
Why?
Honor. I'll file next day positively.
Tomorrow.
There was some other suitably were not available because decision, even the claimant also is not keeping well the whole each.
You wait for the claimant to die.
No, Your Honor.
And then
For 1 week, sir.
counsel for the claimant, Shri P. present. Counsel for the OP insurance bracket Bajaj Allianz. She's this W present. Against the owner and the driver, it is
Yes,
proceeded ex
yes.
parte. The matter is proceeded ex parte against the OP owner and driver.
This one, we can do.
Huh?
Dated 1 February.
Okay. Just put in the file cover for you. Another counsel for the claimant, prays for time for filing the deposition of the witness CW's on affidavit. Pray allow. How much time you want?
2 weeks.
2 weeks. 2 weeks. Yes.
Okay.
Any of them. Okay.
MACA 2023.
Yeah.
Zuliana Liberty General Insurance.
Yes.
For the OP number 1 and 2, driver and
Yes.
it's fixed for step by the claimant. File substitution application as instructed. As instructed on the other dated 16.
No, you are appearing for the legal aid.
They haven't filed any substitution as of now.
Huh?
I'm appearing for the legal aid. But however, the name of whom they want to substitute that was not mentioned on the substitution application.
Fill the order dated. Fill the order dated
16.
order dated 16/10/2025. The claimant had filed substitution application in a very cavalry manner. The claimant had filed a substitution application in a very cavalry manner. The OP number who died?
Number 1, the owner.
The OP owner died on
26/3.
26/3/2025. The OP driver, the OP owner died on 26/3/2025, which has given rise to a substitution application filed by the claimant. Full stop. The claimant had simply filed a substitution application without mentioning who are the legal heirs. Who are the legal heirs? Comma, prospective OP number 1. This code. was pleased to allow the claimant to rectify the substitution application by adding the name of the legal heirs intended to be made a party as party number or as opposite party number 1. No step has been taken by the claimant. Substitution application stands dismissed. The claimant shall satisfy this court in absence of the owner whether the claim petition is maintainable. The claimant shall satisfy this court on the death of the owner and the legal heir not being substituted, whether the claim petition survives for consideration. Yes, next.
Lari Kupar, Mini, Duarte,
Yes. Yes.
Your, in this case, as last date, 2 weeks before, we have considered the charge. I'm appearing for this Duarte Kibuma. So,
No. You may concede to the charge. What are the sections? What are the sections charged?
section 7,
Section charges 7B 13
120.
of PC Act.
Yeah.
Of PC Act is section 7 and 13. And IPC 120B 409 2034.
409 is tribal by?
Ministerial.
First clause.
We asked the prosecution last day that during the course of hearing, the question of sanction under section 19 of the PC Act had cropped up. The other parties shall satisfy this court if the prosecution can be allowed to obtain sanction at this stage.
Your Honor, gone through many citations. It was prior cognizance. It can be, however, as this court has already issued summons, so cognizance is.
No, we are framing charge. Cognizance means we can take cognizance in the PC Act, we can take cognizance without the case being committed. We have got original jurisdiction here. It's not that the case has to be committed, and cognizance is all right. We can we take cognizance of the offense. We are on the question of prosecution starts when? After framing charge. Yeah. The trial commences after framing charge. So even if we have taken cognizance of the offense, cognizance of offense, the moment the FIR is filed, the FIR is before us.
Yes.
These PC Act cases need not to be committed to this court. Section 4, we can take cognizance of the offense without the case being committed. So that is not issue. But then we are yet to proceed with the trial. Can we frame charge without there being a sanction under section 19? Now, if not, then we send it to the magistrate and drop the charges under PC Act.
I have one decision. It's very good decision by the Allahabad High Court. 1983 SSC online, Allahabad. Let me read out.
Yeah.
It's slides copies.
Let's read. What is it?
Basically, this accused person here, do they have been appointed for a project? This basin.
Last date we say that the question whether they are public servant or not.
Okay.
You have seen the definition. They have been entrusted with the responsibility
Yes.
of dealing with public money.
Public money. So
So they will come within the
duty.
definition of public servant. That we have dealt with.
If I may read out,
Yes.
this case which I have placed for this honorable court is that in paragraph 9.
Yes.
Towards the end, observe. As the applicant was not a public servant on the date of which charge sheet was submitted, against him, sanction to prosecute was not necessary.
Right.
So basically, the accused here, all the accused, they were terminated prior to charge sheet of this case. So they are no longer serving as the.
You mean to say that if some people are caught doing some illegal act or the act constitutes an offence under the PC Act, by the time they file the charge sheet, departmental proceeding is initiated against him and he is terminated from the service. So he is no more a public servant. He was dismissed because of the mischief he did during as a public servant. It is not the time of filing charge sheet, but at the time of the commission of the offence, his status important.
Rightly said, sanction to prosecute was not necessary.
If the person at the time of committing the offence was not discharging a public duty or he was not a public servant, not at the time of filing charge sheet. See, it is quite clear that this section applies to an offence being committed by a person who was public servant at the time when he committed the offence. That's what I'm saying.
At that point of time, they committed offence.
Yes.
Yes. They have committed offence when they were performing their duty.
Yes. That's the act all about. After that, whatever maybe, if that is the case, then everybody after committing the offence, they'll resign. And they say that I'm not a public servant. You can't file charge sheet against me.
This is the case here, sir.
In our opinion, further clear that the sanction to prosecute a person is required only when he happens to be a public servant on the date on which he is prosecuted. The prosecution starts when?
Prosecution is when trial begins.
No, because the crucial date on which the sanction for the prosecution is required is the date on which the court is asked to take cognizance of the offence mentioned in the section. The section, yes, we are not cognizance of the. See, for the purpose of investigation, we take cognizance of the offence.
But in the trial,
yeah. So we take cognizance of the offence, and then later on we take the cognizance. But that's all right. That's understood. There's nothing to be discussed about. If the person at the time of the commission of the crime, what is important is that what is the status of a person. Otherwise, every civilian can be roped in under the PC Act. And if you go by the argument is that the person.
No, in this case, it's quite different. It's not about any other civilian can be roped in. In this case, which I'm relying on, he was a servant, public servant at that point of time when he was caught. Yes. Similarly here also.
When he was caught, he was a public servant.
Yes.
But that's important. I mean, that's I think.
So I mean to say why there is no sanction now, because after they have been terminated, so sanction is unnecessary.
The private person can be prosecuted under PC Act.
No.
Yes, why not? If he is in the conspiracy with a public servant.
Yes, in this case, all of them are public servants.
Even a private person can be prosecuted.
Yes.
Even if a person is not a public servant. Yes. So that is something very trivial. It is a settled position is that that at that point of time, his act was in discharge of a public duty. Now he can discharge public duty if he is a public servant.
Yes.
So after that, if he is dismissed from the service or he resigns, that does not dilute the offence. Time of filing charge is irrelevant. It's at the time when he committed the offence. Suppose a person is a foreigner.
Yes, I agree with some. Yes. But the thing here is in this instance case, that the accused has been terminated prior to charge sheet prior to charge sheet of the case.
It doesn't matter. What difference does it make?
But the Honorable Court has observed that.
No, but I don't think so. There is something we should waste our time in understanding these trivial matters. If a person is a foreign national, he enters in this country, charged under Section 14. After that, he acquires the citizenship of this country. That his entering in the country is legalized. That point of time, he was a foreigner. That's very important. When he entered in this country, he was a foreigner. At that point of time, when he committed the offense, he was a public servant.
Yes, yes.
Thereafter, what happens if what you are saying is that at the time of filing charge sheet, if you're not a public servant, sanction is not required. All public servants, after committing the offense under the PC Act, will go and resign. And after committing the PC Act, 20 days, 48 hours, they're suspended. DP initiated, they'll be terminated. In some cases,
In this case, there is no DPU as they are contracted.
in some cases, even government servant DP can be exempted by the governor. No departmental proceedings straight away under the constitutional scheme, they can be terminated. If the offense is so severe that he said, we don't hold departmental inquiry, just terminate it. Termination or the not being public servant after the FIR was filed, that will not change the status of the accused. But the question here is that at this stage, at the time of framing charge, if it's brought to the notice of the court that there is no prosecution sanction under section 19,
Yes,
can the prosecution obtain the sanction now? That's only the question here. You are framing, but even if you say we can't frame charge in absence of sanction. Now, if you say that they cannot obtain sanction now, then we will say that we can't take cognizance of the offense under charge cannot be framed under section offense under the PC Act, and then we will send him to be tried by the magistrate under 409. Because trial by the magistrate,
sanction can be taken at any stage, but prior to cognizance taken by the Supreme Court.
Prior to framing charge, we cannot proceed with the trial. Do you say that they cannot produce sanction?
There's some decision of Supreme Court to the defendant.
Sanction can come anytime.
Without questions, Your Honor, actually there is, they can produce at any stage before the cognizance of the offense. But the context in this case is different. We want to know whether the concerned investigating agency have acquired the sanction from the concerned authority. That is the first question. If have not, then that cannot be obtained at any stage of the will and pressure of prosecution.
See, we are not in a proceedings altogether which has commenced now.
Yes, Your Honor.
They have supplied you the copy of charge sheet, isn't it?
Yes, Your Honor.
Sanction is there?
No.
Then, if they say that sanction is there, should supply the sanction.
Well, I'm saying there is no sanction.
They admit there is no sanction. So if there is no sanction, then go. Now the prosecution says that that's what the last order says. This only.
Yes, sir.
Last part of my order says that you satisfy that they can't obtain sanction now. Or the prosecution is satisfied that before we proceed for the trial and frame charge, we can always obtain sanction because we have not started prosecuting them.
That is the law.
Yeah. They cannot obtain sanction now.
Your Honor, in regarding to this point, that whether they have the power or they will be allowed to take a sanction at this stage before taking a consent. So we require a little bit more time.
No, they can obtain sanction. ECI. You've been charged under section
7.
13. Now, who will give sanction? In their case, who is the competent authority to grant sanction under section 19?
This has not been brought to my knowledge also in the charge sheet. This has to be, I also have to seek instruction on that one.
Yes. You have anything, otherwise we'll frame charge. We'll challenge the order, we'll go to the higher court. We'll frame charge. We'll hold that they can bring sanction.
So
we'll give them time to bring sanction order.
For framing of such, as per the section 19 cannot be taken into cognizance of the trial, until unless
All right, we'll give them time to bring the sanction order.
we will deem void, invalid at a later stage.
Satisfy me.
It cannot
Satisfy
be.
me why we cannot give them time to bring the sanction under section 19. Show me which law prohibits them from bringing the sanction order.
There's no bar, Your Honor.
Then it's all right. If you say
But
there's
there
no,
are two aspects, Your Honor.
no, but no, nothing. When you admit that there's no bar, means why should we come in the way of the prosecution?
But however,
If there's a bar, show me. If there's no bar, then we'll proceed.
the bar for cognizance, Your Honor, there's a bar under
What is
19.
cognizance of?
Cognizance for taking cognizance from this honorable court, special court.
What do we exactly mean by cognizance of?
For framing the charge of the accused.
Have we framed?
No, Your Honor.
Then that's what we are saying. We have not framed charge. We say that one of the prerequisite is that there should be a sanction under section 19. If they cannot bring the sanction.
Yes, Your Honor.
See, Swami's judgment you have read. If sanction is not granted within 3 months, it will be deemed sanction.
Yes, sir.
Then, if they apply for sanction and the government does not accord sanction, it will be deemed sanction.
Yes, sir.
Not required sanction also. The job of the prosecution is only to apply for sanction. If no sanction is accorded, it will be deemed sanction. But if you have any argument, any authority to convince us that they had enough opportunity to obtain the sanction. Now, without obtaining the sanction, they filed the charge sheet. Now, at this stage, they cannot obtain sanction. At the most, the offence under the IPC will remain in the charge sheet to be tried by the magistrate. If that's the argument you have, I am ready to hear it. This is what we said my last order, last part says only, during the course of hearing, this question of sanction under section 19 of the PC Act had cropped up. Rival parties shall satisfy this court if prosecution can be allowed to obtain sanction at this stage. Prosecution should satisfy me that they can obtain sanction now, if there is no bar, and you on your part, you tell us that no, you cannot. Tell me. How much time do you require?
Yeah, I'm not aware of how much time. This depends on the authority.
No, not authority. 3 months time not granted, it will be deemed sanction. Sanction for prosecution, both under same principle applies under section 197, section 19. What do you have to say? Anything? You have any objection in this? We allowing them to file a sanction? If this objection, please tell us. We'll record the objection and dispel it.
No, only one question, because I'm a little bit confused with that. Whether the concerned IO has put an application for sanction or they have not.
That goes against you. If they say that we have applied for sanction,
yes, sir.
Then no need sanction. Then sanction is not required. We can say that it's deemed sanction.
And if they have not applied till yet, it will become deemed sanction, Your Honor, by this stage.
If they have applied and the government has not accorded sanction, if the sanction is refused, then there is no question of filing charge sheet. Because no sanction is accorded under 19, then they can't file charge sheet. But if they have applied for sanction to prosecute you, and the government has been sitting over the sanction for years altogether, and they file the charge sheet, they can rely on that Swami's judgment, and they say that we have applied for sanction. After 3 months, it's deemed sanction. So we'll grant you time. We'll grant you 1 month time. Yes. To obtain sanction. All right. You have any objection? We'll record it for granting time for sanction. Now, no more question of section 19 sanction is not.
I object, Your Honor.
What is the objection? Object means what object? This is not some protest procedure. No? Tell us what is the objection. Tell us what is the objection. We'll record it. Evidently, the prosecution has not obtained sanction. for prosecuting the 3 accused persons. The accused persons they were serving as what? These accused persons?
DPMU, Your Honor,
As what?
District Project Manager,
Okay.
one of the accused.
The accused persons falls within the definition of a public servant. A charge sheet has been filed in the instant case for an offence under section
713 PCI and then
713
and section 120B 409, 420 and 34 IPC.
Here the sanctioning authority itself they filed the FIR.
This one.
Deputy Commissioner.
No. Project is the head of this project.
Who terminated the service?
Come from the basin development.
Who terminated the service? They have been terminated from the service?
Yes.
Who terminated the service? The person who has the authority to terminate the service will be the sanctioning authority under section 19. What is it? Section 713. 713 and which section?
713 PC Act. Yes. 7.
PC Act 1918 and then section 409.
We will give for this section.
At this stage, this court is not inclined to inclined to drop the charges under the PC Act. in absence of the sanction, in absence of previous sanction for prosecution under section 19. The prosecution is given 1 month time to obtain sanction from the competent authority for prosecution of the 3 accused persons fixed by the prosecution to produce the sanction.
Copy be communicated to IO.
Copy of this order shall be communicated to the IO. The above order has been passed, allowing the prosecution to obtain sanction inasmuch as the trial has not commenced and it is at the stage of consideration of charges. The defense have failed to satisfy this court that at this stage the court cannot allow the prosecution to obtain sanction under section 19 of the PC Act for prosecution fixed for production of sanction by the prosecution. Yes. Yes. Good. Any witness? Yeah. Yes.
There's one argument, but the prosecution is on observation.
Yes.
We are not allowed, maybe let the defense.
Your Honor, this case against the accused person, Gerald Suchian, was lodged by the complainant in the one. I may be allowed to read the FIR.
Who is the accused?
Gerald Suchian is present. In custody, yes, sir.
Yes.
If I may be allowed to read to the officer in charge, Brilliant Police Outpost FIR Persha ya Gerald Suchian. Katkum katai ka phang bala kadau haneng ni ke bahian asam mikwa mbo ka jing unjor Persha ya Gerald Suchian. Ukhon jong ka delina Suchian besong basa mukham. Namar pamenta kesngi atun retorik na bispau arja katra. Akupor komba spau statement step ulu permit saw ya kabar bira Suchian. Da kabaot narendang da katari hayeng jongkahi mukham. Bala penkit marmar CSC laskai. Namar ba kala shitom jol doktor kila refer ya isha civil hospital yalam. Yo ya kajing sumar ka papaka. Tingikum ki bahing asam ikarpat ya pi pensawah shimkya ya kani Jaintia. Ya kajing la bahajong pi ya pertujunan.
The PCA.
So soon after the FIR was lodged, Your Honor, a case was registered, and Section 326 and 307 of the Indian Penal Code was charged against the accused person.
FIR was filed by whom?
FIR was filed by Shamhang Latham, Your Honor. PW1.
Yes.
So, Your Honor, the accused person, he was arrested on the same day, on the 26th, the day the FIR was lodged.
What is your relation with the victim?
His grand auntie, something.
Is it old lady?
Yes, Your Honor.
Barbiro.
Barbera, yes, Your Honor.
Barbira na Barbiro?
Barbera.
Yes.
So this case was after the investigating officer has completed the charge sheet. He has filed the charge sheet. On the 13th January 2019.
Yes.
So, charge sheet number 2 of 2019.
Yes.
The alleged knife which was used in the commission of the offense was seized, Your Honor, in this case. And afterwards, Your Honor, someone was issued to the witness who came and deposed before this court. Your Honor, I would like to start with the complainant in this case.
Yes.
If I may read out this evidence, Your Honor.
Yes.
PW1. I received someone to appear before the court. I know this case. I know this instant case. I also know the accused person, Shri Jara Suchiang, as he is related to my wife. On the day of the incident, I was in Mokap village. On the said day, while I was passing through the road and on reaching the house of the victim, I saw the son of the victim crying in the compound of the house of the victim. And I asked from him of what had happened. And he told me that he does not know as he did not see who assaulted his mother. I immediately called and informed the village members about the incident, and the members of the village told me that as they are already in their workplace, they requested me to do the needful. I contacted one person from the same village who is working in the district council office, Joy, and he told me that the police will be reaching the village soon. Since the police did not reach the PO on time, the victim's family members, including me, took the victim to Laskin CSC for medical treatment. After a while, the police also came to Laskin CSC. At the hospital, the elders of Suchiang clan decided to report the matter to Reliang Police Outpost. On reaching Reliang Police Outpost, I sat outside the police outpost while the elders of Suchiang clan entered inside the outpost. After some time, the police called me to get inside and told me to put my thumb impression in some paper, which I do not know the contents as I am illiterate. I cannot remember whether police has recorded my statement or not in this instant case. So, Your Honor, looking at the evidence of PW1, this witness, Your Honor, he's the informant in this case and he's a member of the village, Mukhap village, Your Honor. And from his evidence, Your Honor, he never stated anything about the accused person being involved. He never stated that the accused person is involved because on inquiry, Your Honor, from the son of the victim who was in the compound, he stated that he did not see who assaulted his mother. However, the FIR in this case was exhibited before this court.
PW1 is the author of the FIR.
Yes, Your Honor.
But he didn't say that he wrote the FIR. He had just put his hand in the FIR.
Yes, Your Honor.
He's an illiterate person. Who wrote the FIR? He does not know.
Yes, sir.
What is the fact stated in the FIR?
The fact stated in the FIR is that the accused person has got the victim, Barbara Suchian.
Read the FIR again.
Katkum katay ka phang bala kadaw haneng ni ki bahiyang asam ni kwa man bo kajing ujor persha ya ujero Suchian ukon jong kadelina Suchian basham basa hamukhap namar bamenta kasmi aka apondre trik na bishpau aja pra haka por kumba shpau stang em ula pan saw ya ka Barbara Suchian da ka ba ot narandang da ka tari hayeng jong kahi hamukhap ba na penket marmar syasi esi laskay namar bakala shitom jor ki doktor ki la refer ya isha civil hospital ya long ban yo ya gajing sumar ka bapaka tingi kum ki bahiyeng asam ni ka pat ipi pins shim kya ya kani gajing jia ya gajing le ma jong pi ya perto juno that is the FIR.
Yes.
So Your Honor, coming to the evidence of the victim before this court, Your Honor, can you allow me to read her PW2. She's the victim.
Yes.
I received someone to appear and depose before the court today. I know this instant case as I am the victim. The incident occurred on 26/10/2018 at around 8:30 a.m. On the day of the incident, I was at my residence at Mukhap village. I was at home with my youngest daughter, Shrimati Marbotki Suchiang, and the accused Gerald Suchiang. At that time, I thought of going to my paddy field at Mogeao village. During that time, I have asked the accused Gerald Suchiang by tapping him to also go to the paddy field of my sister, which is also at Mogeao village. As such, the accused got agitated and thereafter he pushed me to the ground inside my house and I fell unconscious. At that time, my daughter was also present outside the house and only I and the accused were present inside the house. Thereafter, I could not remember what happened, and when I regained consciousness, I saw a cut injury on my chin. I know the accused Gerald Suchiang as he is my nephew. When I came back to my senses, the accused has fled away. That is the evidence here.
Medically examined, lady?
Yes, Your Honor. Medically examined by me, Your Honor. I agree to the suggestion that as the accused was not present when I regained consciousness, he may want to call out somebody for helping me. I agree that the accused did not have any intention to hurt me at that point of time. When the incident took place, both I and the accused were under the influence of alcohol. It is a fact that the incident took place accidentally. I do not have any grievances against the accused person and wants him to be discharged from this case. It is a fact that FIR in this case was filed by the clan members without my knowledge. The complainant in this case is my brother-in-law, and I was not aware that he had lodged the FIR in this case, and if I knew that an FIR would be filed, I would have stopped him. I have not stated anywhere that the accused had got me. Till date, the accused is close to me and is a helping hand in my cultivation. That is a cross-examination. Your Honor, the eyewitness in this case is PW3. PW3.
PW2 is the injured.
PW2 is the victim.
Yes.
PW3 is the person who was present along with the victim and the accused person are there. If I may be allowed to read, Your
This
Honor.
is Srimati Marbutki.
Yes, Your Honor. Marbutki Suchian.
Right. Mm.
I received someone to appear and depose before the court today. I know this instant case as I am the daughter of the victim and the cousin sister of accused Gerald Suchian. I cannot remember the date and month, but the incident took place in the year 2018 in the morning. On the day of the incident, when my mother was drying paddy outside her compound, and also the accused Gerald Suchiang was present in the house of my mother. As it was a reaping season of paddy, my mother instructed Gerald Suchiang to go to the paddy field for cutting paddy. Then accused Gerald Suchiang refused to do so, and as such, it has led to a verbal spat. After that, I took some clothes and went to a place called Umso for washing clothes. When I returned back home, I saw my mother injured below her chin and was lying on the ground unconscious. Then I informed the matter to our family members, and my mother was later shifted to Lasken CSC for medical treatment. From Lasken CSC, my mother was referred to Civil Hospital Juai, and she was admitted for 1 week in the hospital. On the same day, after my mother was shifted to Lasken CSC, the accused was also arrested by the police. The accused is present in court dock today. That is the evidence.
Ross?
It is not a fact that the incident took place at around 9 p.m. as it occurred in the morning. It is not a fact that my mother's neck was slit, but she was slit just below the chin. I stay in the same compound with my mother, though in a different house. It is a fact that prior to the incident, the accused person used to help my mother in the field like I do. The accused never had any adverse remark in the family prior to the incident. At present, the accused used to help in the cultivation work of the family. After my mother was discharged from the hospital, we never discussed about the incident. My mother used to take alcohol sometimes. As I did not witness the incident, I agree that my mother could have fallen down and injured herself. Whatever I have stated before the court today is the same statement which I have given to the police. It is a fact that the matter has been compromised within the family. I want the case to be disposed of as we have forgiven the accused person. That is the evidence of PW 3 of PW 3.
Could you read the statement of the victim recorded under section 164?
One 61.
164.
Copy was not given to us here.
Exhibit 5. Medical report. Exhibit 6.
Exhibit 6.
Shall I read the evidence?
I received someone to appear and depose before the court today. I joined medical service on so and so and posted at Namdong PSC on the 10/7/2020.
Reading Exhibit 6.
Your Honor, medical.
Read Exhibit 6 medical report. Doctor is Exhibit 6.
Yes, Your Honor.
Yes, read the medical report.
Deposition.
Medical report. Exhibit 6.
To the in charge Raliang Police Outpost, West Jaintia Hills District Medical Examination Report. Certified that I have examined the following person at Laskin CSC at 12 p.m. on the 26/10/2018, and the following are my findings. Shimiti Barbara Suchiang, 57 years, female, daughter of Yoda Suchiang, resident of Mukhap village. Complaint of alleged assault by a known person and sustained a deep cut throat injury today at around 10:30 a.m. On examination, conscious, altered, oriented to time, place, and person, hoarseness of voice. The BP of the victim is shown here on 80/60. External injury. A large 10 centimeter into 5 centimeter incised cut throat injury involving anterior aspect of neck just below chin and left side of so and so on. The impression given by the doctor. The above person has consumed alcohol and she is under self-control. She also sustained a grievous injury and the above mentioned site for which first aid treatment given and hence refer to higher center for further management.
Yes.
So after she was referred, Your Honor, to higher medical. However, Your Honor, on questioning the IO of this case, Your Honor, who is PW7, the IO in para 7, Your Honor, he admitted that he never produced any document to show that the victim was
What?
the IO, Your Honor, investigating officer, even though the doctor has referred this victim for further treatment to civil hospital, Your Honor. However, the IO in his cross-examination in para 7, he admitted that he has not submitted any document to show that the victim is hospitalized.
What is the explanation to the injury suffered by this lady, measuring 10 to 5 centimeter on her neck?
Your Honor, the medical report, the first medical report which was submitted before this court, Your Honor, shows that after this incident, the victim was taken to Laskin CSC. The report goes to shows that 10 centimeter and 5 centimeter in size cut throat is upon the survivor victim, Your Honor. However, Your Honor, this report itself, Your Honor, goes to shows that had the report been serious in nature, then the doctor who have given the treatment first, Your Honor, he should have shown, Your Honor, that some stitches were given to the victim.
All right, but what is the explanation? No stitches.
As per the report, there's no stitches, Your Honor.
What is the explanation about this lady who is your auntie? PW3 saw you in the house. PW.
She only saw, Your Honor. But at that time, when the accused was with the victim, she went to wash clothes. So it was only after she returned back, she saw the victim lying on the ground. She never saw that the accused person assaulted the victim. She was unconscious at that point of time.
Who's the opinion?
Yes, Your Honor.
Tomorrow is there? Take tomorrow. Prosecutor. Yeah, the prosecution is absent, I understand. His counsel is also. Please for the hearing tomorrow. Tomorrow the transfer. Tomorrow something. Yes.
Yes, Your Honor. Your Honor, regarding the accused Kamon Timur, the one who I filed representation, I called his family relative. They informed me that he went to the field harvesting season, so they could not reach him. They are going now to
Where? Which village?
I think Barato side, Your Honor. So if Your Honor, kindly allow him to appear on the next day, because as of now we cannot reach him.
Even the witness did not turn up.